welcoming the participants of the JustCovid International episode 3, discussing how COVID-19 has changed the criminal law practices worldwide. And we have representatives of Armenia, Ukraine, Moldova, and Georgia. We are going to discuss the changes in the practice and policies in pretrial detentions and generally in the criminal law practices amidst the pandemic. So my first question is whether there have been any changes in terms of the governmental institutions or any other institutions, the resulting new requirements to the lawyers for requesting different other regimes like alternative to detention. And I want to give the floor first to our colleagues from Armenia.
I'm representing the Law Development and Protection Foundation, which is basically focusing its activities in the fields of promotion of human rights, the rule of law, and democracy. So as to the question relating to the changes made in the context of COVID-19 to the legislation of the Republic of Armenia, I have to mention that if it relates directly to the COVID-19 context and in fact, using the risk of COVID-19 infection as a ground for applying alternative measures, then no such amendments have been initiated and adopted so far. Some positive changes have been introduced in the system of applying the alternative preventive measures. So, in fact, this has some positive effects on increasing the efficiency of the alternative measures, allowing for using combined alternative measures. For example, the signed undertaking not to leave can be used together with the bail or the personal guarantee. But of course, this is far from being enough to make a substantial change both in the legislation and in judicial practice in Armenia.
Do you have any statistics showing the specific increase in the frequency of the application of such measures?
We don't have the final official data finalized for this whole period, but some figures can, of course, show a positive tendency in this field. For example, pretrial detention has been systemic, excessive use of pretrial detention has been a systemic issue for Armenia for many years, and it has been actually underlined in a number of ECHR judgments, saying that in fact the using stereotyped formula for imposing or extending pretrial detention is a recurring problem in Armenia. About 96% of granting motions for pretrial detention were satisfied by national courts. As to the specific period of COVID-19 pandemic crisis, I can say that we have several actual figures. Figures coming from the lawyers, from NGOs which have conducted some monitoring in this regard, and also the prosecutor's office. For example, the NGO Protection of Rights Without Borders monitored just the cases which are in the phase of substantial judicial examination. For example, the detention motions of 93% were rejected during March 16 to June 30 period, while motions for using alternative measures regarding 58% have been satisfied. This final statistics on that will be finalized, I guess, at the end of the year or at the beginning of the next year, where we can see also, I guess, the decrease in the motions from the side of prosecutor's office to the court.
Now I want to give the floor to Vadim Vieru, our representative in Moldova, who is a human uh, right lawyer. Vadim, could you please share what kind of changes have you noticed in policies or in practice in Moldova amid the pandemic, and what is the role of lawyers in that, whether they are asking for any changes in the pretrial prevention measures or not? Thank you. My name is Vadim Vieru. Unfortunately, similarly to Armenia, we would not notice any systematic changes in the recent months. We can say that percentage of arrests and detentions has decreased in Moldova recently, though I would not say that it has happened because of the overall state policy. But the statistics of the decreased statistics in detentions and arrest has been confirmed by the data provided by the police. And again, this tendency started with the onset of the pandemic. And we can see the 30%, we could see the 30% decrease of the detentions and arrests during the lockdown period. And after the lockdown, actually, the figures went back to what they used to be before the lockdown. Were approximately to the level of 2019. And again, in case when the lawyers or non-governmental organizations or the ombudsmans file applications or proposals to the government for using preventive measures alternative to detention. Unfortunately, the state would not adequately respond, and nothing was done, I would say. And apart from certain protection measures, medical protection measures, I mean, in prisons, but again, there have been no changes in the number of detainees, number of prisoners, or number of persons for whom detention was chosen as the preventive measure or sanction. Thank you very much, Vadim. And now I want to give the floor to Yevhen Krapyvin, our expert from Ukraine, working for the Center of Policy and Law Reforms. I know that for the recent several years, you have been having a tendency similar to what Genya voiced before, the stereotype-based approach to pretrial detentions. And could you please share if the situation has changed recently and what has been the role of lawyers, if this changes, if any? Thank you, Marina. Thank you for giving me the floor, for having invited me to the meeting. So the global problem is still there. Again, the stereotype approach on behalf of the prosecution is again choosing detention as the only measure, actually envisages detention or arrest as the only measure. The lawyers can do nothing about that. And again, the Prosecution General's Office and the Ministry of the Interior have not yet collected any statistics for this year, and it is very difficult to see if there have been any changes. Again, we could only make conclusions or suggestions, I would say, using some information collected by NGOs. And the overall conclusion, I think, today might be that there has been no significant change in the overall tendency. Again, there might be some cases when some alternative decisions were made in specific cases, but no overall change has been observed. Though in some cases, for instance, when formally some prosecutors just prolonged, for instance, the detention periods for some people, automatically, I would say, nowadays there is a chance for the lawyers to use the COVID pandemic as an argument for changing the detention period. And there is also another factor that is not related to the state policy. It was an amendment to the law that was approved in July. This is a legislation introducing a new classification of offenses with a special separate category of so-called criminal offenses rather than as an alternative to severe criminal crimes. And this envisage even home arrest or some alternative measures instead of the custody. So the question is there have been any officially registered COVID-19 cases in detention facilities? Well, my answer would be as follows. We do not have any specific statistics for the detention facilities. There is statistics provided by the Ministry of Justice for detention facilities and prisons. And the police does not provide any data at all. And this, I would say that this is exactly the gray zone where there could be some problem, some hidden problem. Again, I believe that at police stations there is a certain chance to provide for separated, distanced detention of the detainees, etc. Thank you, Yevgeny. And now I would like to give the floor to our representative in Georgia, Merab Kartvelishvili, who is director of the Human Rights Program and also represents the Association of Young Lawyers of Georgia. So, Merab, you have heard the information about the situation in Moldova, Ukraine, and Armenia. And so my question is, what is the situation in Georgia? What is the tactics used by lawyers, and if there have been any changes in the conditions of detention because of COVID, etc.
We are Georgian Young Lawyers Association, and we implementing the court monitoring project since October 2011, and we prepared 14 monitoring reports so far, and one of them was court during the pandemic, and the second one was a preventive measure usage standard, and I will speak about on both briefly, but firstly I want to speak what we have in Georgian legislation about the preventive measures. For now, I can say that we have only 4 main preventive measures. It is detention, bail, personal surety, and an agreement not to live and behave properly. But I can say that only 2 types of preventive measures are applied in practice. It is detention and bail. Other alternative measures are not actually used, and there can be said that there is 2 main reasons why the other preventive measures are not used and are not workable in practice. First, it is the problematic law, and the second one is this, that the parties and the court itself do not think that these measures are as real alternatives of detention and bail. So we have this problem, and because of this law problem and because of the problematic approaches from the parties, we have statistic in our reports. We all time say that 98% of the used preventive measure, it is bail and detention. For example, in last year, 50% was remand detention and 48% was bail. And in our report, we are speaking about the unsubstantiated imposition of remand detention as well. And we identified that 21% of the implied remand detention was unsubstantiated. So we think that it is a very high number of the unsustained imposition of detention. So what is the situation now, and what is the law under the pandemic? We can say that within the reality of the new COVID-19 pandemic, when the necessity to switch to remote litigations emerged, the court managed to timely switch to the remote court proceedings, yet with some hurdles in terms of publicity. As for Georgia, the publicity of remote court hearings during the state of emergency and after the state of emergency was a particular challenge because during the state of emergency, no formal act, recommendations, order, etc., was drafted about the judiciary to ensure the publicity of court hearings. Moreover, but the same there was only one recommendation of the High Council of Justice, which allowed the judiciary to switch to remote mode and limit the number of persons present at the hearing. And also this recommendation did not imply a complete ban to the attendance of those present at the hearing. This said provision resulted in a virtually complete restriction on the publicity of the trial in practice at the initial stage. So unfortunately, from the March till the end of the May, we could not monitor first appearance court hearing. So after the May, we monitored and attended 300 court hearings, and we can say that the percentage point still remains same as it was before the COVID-19, and we can say it is 50-50 in using detention and alternative preventive measures. For the clarification to this statistical information, we searched for the Supreme Court site and found that the percentage of using pretrial detention was the same. It is the same. It was the last year, and it is under the states and court statistic 48%. But we can say that number of arrests is decreased this year, and if last year was 5,000, it is like 4,000. But we can say that it is because of the lockdown that some of the fundamental rights were limited, and these limitations made the decrease of the crime and not the change of attitude of the police or prosecutor side. So what we can say for now that we attended 300 court hearings, and unfortunately in none of them nor the lawyers and defense side nor the court mentioned the pandemic as a reason why it is not appropriate to use detention. We also, as I already mentioned, we wrote the preventive measure usage standard research, and in our study, we proved that the confidence of the parties and the court toward alternative preventive measures is problematic along with the existing gaps in legislation. And we think that a wide range of preventive measures will reduce to a minimum the case of bail and detention. Firstly, of course, detention, we are meaning detention, where the court or parties resort the argument that other alternative measures do not exist. So briefly, I can say that the government, the judiciary, prosecutors, when we are speaking about to make the wider preventive measures they all agree with us that yes, we need some other preventive measures, workable preventive measures, but in case no one addressed to the parliament and parliament itself doesn't start to change the law. So for now, we can say that the COVID-19 situation did not change the attitude of the court nor the parties, unfortunately. And what about the situation in prison? Unfortunately, we do not have the full information about this case, but there was very few accidents of COVID-19, as we know, from the Ministry of judicial justice, and also one of the main argument and the main institution who works about the penitentiary monitoring process is public defender's office. So we from these two institutions we can say that there were very few accidents in prison of the COVID-19 accidents.
Thank you very much, Merab. There has been any window of opportunity opened for a dialogue or for a discussion within the prosecutor's office, within the bar, or maybe among the human rights defenders about the need to change the practice amid the risk?
What about the dialogue between the bar association, judiciary, or prosecutor side? There was only 3 meetings, as I remember correctly, about how to switch on remote court hearings, but not about to change attitude of using preventive measures. So why it is problematic? When we had meetings with judges, prosecutors before the pandemic, they all times spoke about that when we are speaking about the personal surety, there should be trustworthy person that shall assume a written obligation to ensure the appropriate behavior and should be attended in the court. And it is quite difficult to find it for 24 hours. So judges said that there was not a person who would do it, and I can't use this preventive measure. What about an agreement not to live and behave properly? In this case, judges talks about that the current law, the preventive measure, this type of preventive measure only is used only for the offenses that are punishable with up to 1 year imprisonment. So we are limited and we can't do anything about it. And please change the law, and then we can start to use other alternative preventive measures. And the same situation is with prosecutors, because they all the time speak about that the only detention could help this situation, because there is some risk to violate some rights or something like this, that they all the time speak about this. And what we found last year was that the 66% of the prosecutor's office motion of the pretrial detention was granted by the court, and this is quite high, quite a big number, we think, because 66% is quite a high number, we think. And of course, this shows us that there is need to change the law. But the parliament's position is the same, that we are going to speak about it, and we see some problematic issue, but in real, they do not do anything. And we are hoping that January or February, we will think that we will do some legislative proposal to the parliament to change and to make some amendments in criminal proceedings code.
Thank you very much, Merab. And now I would like to give the floor to Vadim and ask Vadim, what is the overall situation in Moldova? What is the role of prosecutors? How open the prosecutors are to change compared to the pre-pandemic situation? And what is the role and the attitude of judges? For instance, in November or December last year, we had some promises on behalf of the judicial system that the practice of pretrial detentions would not be so massively used as it was used before, and some alternative measures would be used. But in Moldova, I would say the pretrial detention was also used as a measure of putting pressure in some political, I would say, cases. During this year, 2020, there have been some changes, structural changes made in the prosecution system, in the judicial system. And like, for instance, in 2019, we had 13,000 criminal cases filed in court, and out of these 13,000 criminal cases, there were about 2,000 motions filed for. Yes, and there was also a decline in the number of cases. Then the prosecutor's office demanded pre-trial detention. It was there was a decrease in March and in April. So we could see that the prosecutors were less inclined during the lockdown period to demand pre-trial detention as a measure. But I would say that it was indeed because of the high risk of infection in the pre-trial detention facilities. Even despite that situation, in some cases, the prosecutors did insist on pre-trial detention. And I would say that there was no official dialogue between the prosecutors, the lawyers, and the judiciary. There was no official initiative on behalf of any stakeholder, I would say, and the Ministry of Justice actually made some statements revealing that no systemic change was envisaged, even despite the COVID-19 pandemic. This is something that they actually unofficially declared after the Ombudsman in April asked to apply the amnesty to certain prisoners, again arguing that with the fact that there was a high risk of COVID-19 spread in detention facilities and in prisons. But it was then that the Ministry of Justice officially said that no systemic change was planned. Thank you very much, Vadim. And now I want to give the floor to Genya. Genya, could you also please share on the role of lawyers, prosecutors, judges in Armenia, and if the practices in the region and worldwide have changed, have influenced the situation in Armenia, and if the judicial practices have changed during the pandemic?
Thank you for the question. I would say that after the prosecutor's office, in the beginning of April, there was a public statement by the general prosecutor based on the CPT's recommendations of the Commissioner for Human Rights of the Council of Europe, and also several cases of infection registered among the staff of one of the penitentiary institutions, to the territorial prosecutor offices for reviewing all the pending cases, both in the phase of pre-trial investigation and in the judicial examination stage, and separate those cases where the detainees are actually in the high-risk group for COVID-19. And based on this examination, there was supposed to initiate a process of reviewing the preventive measures, especially pre-trial detention, both by the prosecutors directly in case when the case is in the pre-trial investigation phase, and submitting motions to the national courts where the case is already in the phase of judicial examination. And as of May of this year, according to the official statistics of the General Prosecutor's Office, there were 3 persons who were the alternative measures were used to whom by the Prosecutor's Office themselves, and 18 persons, motions regarding 18 persons were submitted to the courts and were all granted by the courts. As after the May, we do not have any new statistics. There was also inquiry by our organizations to the General Prosecutor Office asking for new figures in this regard, but they have not finalized statistics so far. I don't think that these numbers are actually making any substantial change. However, this was kind of a public call and a public position on the side of General Prosecutor, which I guess will to some extent also decrease the number of new motions for using pretrial detention to courts. And there was also a public call by the Minister of Justice referred to all the law enforcement bodies, again asking to refrain from submitting motions to use pretrial detentions as far as possible in the context of COVID-19 pandemic. Lawyers, I can say, usually use this risk of infection with COVID-19 in their motions for changing the preventive measure for a non-custodial one. And mostly the motions relating to detainees in the high-risk groups for COVID-19, for example, older persons with pre-existing medical condition are successful. But there are also motions hypothetically referring to the risk for the spread of COVID-19 without specifically substantiating the case and the medical health condition of the person under detention. Those motions, I can say, usually are not granted, and there is also no argumentation on the side of prosecutor's office in the court saying that, in fact, the figures of spread of COVID-19 in pretrial detention facilities in penitentiary institutions is very low. It's just according to the figures of the Minister of Justice, there was just 2 cases of infection among detainees. There were about 70 cases of infection among the staff of penitentiary institutions. And another argument brought by the prosecutor's office is usually that in fact, in detention facilities, safer conditions exist for preventing the spread, and there is actually no real danger for the inmates. Again, taking into account the statistics. And the courts, when we just study the decisions of the courts, we can see that they usually very often refer and cite the CPT's recommendations and refer to the specific medical condition of the detainee and try to substantiate with these arguments the change for an alternative measure. Of course, this is all done in the larger context of the case, factual circumstances of the case. So the risks, general risks of absconding, of obstructing investigation, of interfering with the justice are also taken into account.
And now I want to refer the question to Yevgeny. What are the tendencies and what is the attitude of prosecutors in Ukraine now? I will try to bring you some figures. We have not had any amnesty. We have not had changes. There have been no changes in the detention conditions because of the pandemic. So this situation has remained the same. In Ukraine, we have over 50,000 people in prisons now, and officially in the penitentiary system today there have been a little bit more than 500 cases, and most of them are among the staff of the penitentiary system institutions rather than the prisoners or detainees themselves. So out of the 500, there are only 100 people who are prisoners or detainees officially diagnosed with COVID-19 over the month starting from March. And of course, we also need to consider the number of COVID tests. And it's really funny. So over this period, only 1,600 tests have been made in the penitentiary system. And according to the statistics, again, actually every third person tested positive. So if we increase the number of tests, we would have a proportional increase in the number of COVID positive people. So again, we have this dilemma because we have this low statistics of COVID-19 in the penitentiary, but also very low figures of the testing. And recently, there has been a publication describing the decrease in the prison population in different countries of Europe and the world by 15, 16% in different countries. But the overall figure for Europe is about 4.5% decrease of the prison population. And in Ukraine, there has been a decrease of the prison population also by 4%, but this has not been associated with the pandemic. But this is just the expiry of the period of imprisonment for the people, but it is not at all related to the pandemic. And back in April, there was a discussion during the first lockdown in the parliament of Ukraine. There were 22 legal initiatives considered in the parliament, again, to make changes in the judiciary approach to people with certain medical conditions associated with high COVID risk, like the elderly, people with certain diseases, etc. And there was also another bill about the preliminary release of those people who have committed minor offenses. And if the bill had been approved under certain categories of offenses, about 20 to 50% of people who are currently in prisons could have been released. But actually, the parliament did not discuss, did not consider and approve the bill. And the reason is the president is afraid to release, to discharge these people from prison because they might commit crimes again, because the economic situation in the country is very poor. There is no resocialization mechanism in the country. So the people could be left alone in this very poor economic situation and might be urged to commit the crimes again, which would deteriorate the overall criminal situation in the country. Again, many politicians, many lobbyists brought the examples from Europe, from the United States, to argument the need for such legislative change. But unfortunately, everything was in vain. And again, if people develop COVID-19, they are sent to, again, penitentiary hospitals. And even if they die there, they never get diagnosed officially with COVID. And sometimes their death is attributed or just to some other diseases. So this is, again, a mechanism of hiding the official COVID statistics in the penitentiary. So again, there is political unwillingness to do anything that might undermine the ratings of the president and the politicians. And I think that if, for instance, again, we release the people who committed the crime only once or are elderly, the risk of recommitting the crime is very low. I want now to give the floor to Genya and ask her about the tendencies in Armenia. Did you discuss such alternatives in Armenia, and what was the response and the feedback?
Actually, there was no public discussion on implementing amnesty in the context of COVID-19. But there is the position of the Minister of Justice in response of a question posed by a journalist on potential use of amnesty as a tool for dealing COVID-19 crisis. However, the position was that there is no need in Armenia to use this tool, taking into account the percentage of loading of penitentiary institutions in Armenia, which is 43%, as opposed to the other states where the overload is more than 100%. And this tool kind of serves the objective of just decreasing the number of inmates. And actually, the Minister of Justice also referred to the statistics of spread of the infection among the inmates in penitentiary institutions in Armenia, which also kind of substantiated the absence of need to implement amnesty.
What about Moldova? Have you discussed the amnesty? We didn't have any bills, any amnesty bills in Moldova. And the practice in Moldova shows that there have been only one or two amnesties in the recent 10 years in Moldova. And again, according to the statistics, those amnesties only partially addressed the problem of overpopulated prisons, and the effect was short-term only. Again, in April, the issue of amnesty was raised to the Ministry of Justice, but the Ministry of Justice actually blocked this issue from being discussed further on. And the issue of applying Articles 91 and 92 of the Criminal Code of Moldova were raised, and there was an attempt to demand release of certain categories of prisons who had serious health-related problems or whose term was to expire within 1 or 2 months. Those were considered as an attempt to somewhat depopulate the penitentiary system. But again, the Ministry of Justice would not agree to apply those measures directly. They also propose certain alternative to those. And now regarding the COVID-19 situation in the penitentiary, according to the data provided by the National Penitentiary System, the situation is controllable in the penitentiary. What does it mean? According to the data published on the official website, there have been 56 cases of COVID-19, whereas we have 6,200 prisoners. This figure is really low if we consider it to the overall COVID-19 load on the civilian health system. Like, for instance, yesterday in Moldova, we had about 1,400 cases. Again, if we consider this figure, like, for instance, to the figure registered in the penitentiary system, of course, the figure for the penitentiary is very low. But again, we should remember that this is the official statistics only, and there have been also cases when, for instance, lawyers said that their client was COVID-19 infected, but uh, the administration of the penitentiary institution didn't want to officially register the person and did it only 5 days later. Then the person was hospitalized and had to spend more than 2 weeks in the penitentiary hospital because his condition was seriously deteriorated. And again, so we cannot say whether all the cases get registered in the penitentiary, but more or less the uh, figures are rather controllable. In prisons, the risk is associated with the fact that there is a parallel healthcare system within the penitentiary system, so which means that actually everybody who develops a disease in prisons has to undergo treatment in the penitentiary hospital system. And these hospitals, these penitentiary hospitals, really lack doctors, nurses, equipment, and resources in general. And one more thing that I would like to mention is that according to the official data, about 50 to 53% of the overall prison population in our country have medical conditions that could lead to very severe forms of COVID-19 related diseases if these people are infected with COVID. Thank you, Vadim. And I have two clarifying questions. First, you mentioned that certain alternatives were proposed by the Ministry of Justice as well. And could you please specify these? And my second question is the attitude to the potential amnesty or the alternatives in the among the public. Regarding the specific alternatives, those were not the alternatives elaborated by the governmental institutions, but rather by the Human Rights Relations, which is an NGO, and the alternative was using electronic bracelets for in certain cases, and for certain categories of people who had committed certain minor offenses. And another alternative was home arrest, home detention, and those were the alternatives. And now regarding the amnesty, I would say that in April or May, the public did not respond to the refusal of the government to declare an amnesty, but generally, according to the recent surveys, the prisoners constitute a group of the population that is most discriminated. And we have a mechanism in Moldova according to which a person who is kept in really grave conditions in prisons, this person would actually be eligible for a compensation or for a decrease of the term. And again, the application of this mechanism resulted in decreased terms or even releases of some politicians who had been sentenced because for corruption and some other offenses. And so the issues seemed to be politicized, and maybe, by the way, that was one of the reasons why the government was not so much inclined to use this mechanism amid the pandemic, to avoid being blamed for promoting corruption. Thank you once again. And now I want to give the floor to Merab. Could you please share about what happened in Georgia in this context?
The real discussion about the amnesty was not provided in Georgia, nor the government or the opposition, or I can say that the also civil society organization did not push the government to make the amnesty. So So in this case, what I can say for now, maybe I don't have the the real statistic for now. How many prisoners are in Georgia? Maybe it's 10,000 or 11,000, but 60% of the prisoners are sentenced for drug-related crimes and the crime like theft. So less severe crimes, we can say. So in this case, when we are speaking about the non-violent crimes and when we are speaking about the persons whose crime is not so so hard to make some decision. Maybe the government should react on it, but you know that we had the election in October, at the end of the October. So nor the government nor the opposition talked about it because it is quite sensitive issue to speak about. So we think that maybe in December or January uh, there should there would be some real discussion about this issue. And when we are speaking about the amnesty, maybe the situation will overcome. And if we are speaking about the non-violent crimes or something like this will happen. But I could not say that I am very optimistic about it. I think that the change of attitude of the prosecutors or police may be more realistic than the amnestation in Georgia.
Amnesty was considered, what was the attitude of the society to the potential amnesty and what was the media attitude. The coverage in media was very superficial, and as it frequently happens, media fail to adequately cover certain cases. And by the way, the last amnesty in Ukraine happened 4 years ago and have been very good analytical reports describing the global context, bringing very strong arguments, again, focusing on the example of the United States. But again, as it comes to this society, the society failed to adequately respond either because they followed the same lines as the president did, that the release of prisoners to the streets of Ukraine would result in them committing crimes again, increasing the aggravating the criminal situation, and then resulting in their detention, arrest again, and even arrest and punishment for crimes that fall under graver categories, I would say. So again, this overall attitude and this trend on using the penitentiary system as the system for punishment prevailed in that case as well, unfortunately. If you can see any potential opportunities for opening up a dialogue and revisiting the attitude of the penitentiary system towards revisiting the system of punishment for minor offenses or for changing the stereotype approaches to addressing some problems that existed in the pre-pandemic period and exist now. So the first floor goes to Merab.
I can say after discussion, I can say that in Georgia, the situation about the COVID-19 before September was normal, but we see last trends from September to nowadays that more than 4,000 accidents happened of COVID-19 and 40 deaths for a day, which is a very high number for the country sized like Georgia. So maybe these situations, these problematic situations, this crisis helps this situation to change the attitude, and it is necessary to change the approaches depending on the created situation. The situation in the country is getting worse, and we are seeing this problem. And maybe what we saw before the COVID-19 about the unsubstantiated imposing of remand detention and the other measures. Maybe this problem and this situation now we can better see this problem in real life. So I hope that the situation in Georgia, we have three types of crisis now, and the economical, health crisis, and political crisis as well. So we hope that this political crisis will be overcome, and after this, the political groups and of course civil society with the society start to think and to change the situation, to, for example, to adopt a new law about the preventive measures, to make a wide range of alternatives. For example, to rethink about the amnesty, and for other solutions of this problem. So we have quite difficult situation, but we can see this as a chance to overcome these problems.
I think that we all need totally new systemic conceptual approaches to change significantly excessive pre-trial detention practice in Armenia. And usually the frequent use of the pre-trial detention is reasoned by the lack of other effective alternative measures in our system. And it is hard to disagree with this position. The new Criminal Procedure Code of Armenia, which is in a draft phase and which has been actually in this pending process for many years, is introducing very effective system of alternative preventive measures, including house arrest, which I believe will be able to make this substantive radical change in the practice, and also many other amendments in the system and the use of mechanisms for the lightest to the most severe ones, and using the pretrial detention as the last exceptional measure when all the other measures prove inefficient. So actually, we believe that adoption of the new Criminal Procedure Code and introduction also in practice of all these new alternative preventive measures, and first of all, house arrest measure, will have an impact, positive impact for substantially changing the practice. And of course, the judicial practice itself and the mindset of judges also has to be adapted to this new approach and a new culture, which is kind of coming from the Soviet era.
Thank you, Genya. Vadim? Regarding the situation in Moldova, and if there is any potential for some positive change in terms of using alternative preventive measures in Moldova and addressing the COVID-19 problem in the penitentiary, I think that the positive aspect is that the National Penitentiary Administration is really interested in using alternative preventive measures. Because again, even though the prison population today is a little bit more than 6,000, again, if we compare the figure to the figures of January 1, 2019, we can see that the number of people in prisons has not significantly changed. And again, if we take into consideration the overall poor system, I mean, the healthcare system, the increasing number of COVID-19 cases, we can see that the fact that the population, the prison population has not decreased within a year is really alarming. And I think that the Ministry of Justice and the system in general understands that more focus should be made on awareness raising and on lobbying the idea of applying alternative measures to the government and to the parliament, because we have some MPs who are very much against any alternative whatsoever. So we need to persuade them that such a new alternative approach would be economically beneficial for the people in Moldova, for the economy, and would help the state save money for the budget. And in conclusion, I would say that most of the court proceedings are carried out online, and by the way, we have seen very serious economic effect. A lot of money has been saved, but the quality has not deteriorated, I would say. So I think this is a positive aspect to the pandemic, that it has shown us the positive aspects of some alternatives. Thank you. Now, Yevgeny, the floor is yours. Practice of the prosecution, the interrogation practices. There is also a practice of online interrogations, and the courts nowadays recognize and admit this as evidence. Though again, we have the histories, they have the cases in Ukraine when people who have been online interrogated then are reinterrogated and reinterviewed in courts. So I think there are some practices and some tools that could be used to decrease the spread of the pandemic in the penitentiary system, because this is the system where the people are dependent on the government and the actions of the government. It is the obligation of the government to do everything to take care of the health of the people who are kept in the penitentiary, and in this case specifically to prevent the spread of COVID-19. Thank you very much, Yevgeny. And I would also mention that there is one more positive aspect to the online regime, to the internet system, and to the media coverage of the situation, is that we can actually keep on track with the practices, whether positive or negative, used elsewhere in some other countries, and then use the lessons learned when we are going to apply same practices in our countries. And on this note, I would like to thank all the experts for their participation, for having shared your observations, shared the information about the situation in your countries. And I want to thank all our participants in the audience.